Hi, Attorney Jennifer Witt here. Do you have a criminal court hearing coming up and you're wondering, what do I wear? How do I act? What should I expect? Well, those are all great questions and I'm going to cover the basics coming up. Hi, Attorney Jennifer Witt here again. So on this video, I'm going to cover what to wear, what to expect as far as arraignments and pretrial, and kind of just the protocol that you should be thinking about when you go to court. And I should preface that with, this is not for trial. If you're going to trial, the trial prep will be quite different. And for obvious reasons, your attorney would meet with you well in advance and discuss, things strategically, as simple as what do you wear, important body language in the courtroom, all of that sort of thing. So this video is really for those who've never been to an arraignment. Maybe your arraignment was waived, so you didn't go to that, and so now you're going to a pretrial, or even you're resolving your case. So this is your first time going to court. So, and I've done videos on this before of things not to say or not to do. I don't know how long ago, but I know I've covered it, so I'm going to kind of put it into a nutshell here. It's really quite simple. Don't get too stressed about your clothing. It's not as fancy as a wedding, and it's not something you'd wear to the gym. So the court staff and the prosecutor and the judge, they know most people don't have suits hanging in their closets. So if you don't own a suit, don't panic. That's different if you're going to trial. You may want to invest in a suit. But if you're just talking arraignment and pretrial, just dressing respectfully, clean clothes, nothing like a concert shirt, preferably something with a collar. But if you don't have it, clean ironed clothing, something kind of boring and, just, I don't know another way to say it. It's not as dressy as a wedding. Don't come in your prom dress. But don't come in with, your Lululemon sports bra and the newest, cutest leggings. That won't go well. And even on this video, I'm wearing a sleeveless dress, which I would put a jacket on if I were going into court. I wouldn't, in most courts, this isn't acceptable, however you feel about that. Some women really think that's terrible. Just to tell you, it's just you shouldn't come in a sleeveless dress or tank or anything like that. Wear sleeves or a jacket. So that's kind of the basics on dress. People get nervous about it, and I understand, but don't sweat it. As far as one more thing on dress, no hats. If you're a hat wearer and just can't break that habit, always have a beanie or a baseball cap on. You don't do that in court. I have seen a couple people get away with it recently, just actually a couple weeks ago in court, and I'm quite surprised. But most courts will make a point and stop court or tell you to remove your hat. So don't do that. Don't chew gum. Have your phone on silence. And as far as the silencing of the phone, I'm going to also, with a caveat that if you're our client, we may have discussed something about that, when and where we want you to check in with us if we're on Zoom, and you have to be present. Typically that's only for arraignment where we practice, but for everyone out there, the general rule is silence that phone. You don't want to get caught with your phone ringing in court. That's a big no-no. So that's the basics to start with. And most people, the biggest worry, which is true not just in court, everyone has great fear of public speaking. So will I have to speak? Generally, no. You will have such limited speaking, you will be quite shocked. When you see it on TV, it's just kind of craziness to me. I just still don't know how TV writers put this stuff out there, because so much of it is ridiculous. But when you go to an arraignment, it's quite simple, and we have done videos on this. They're just asking, do you know what you're being charged with, essentially? Is your name and date of birth accurate? Because they don't want to create an alias. And so you're just going to say, yes, Your Honor, that's my name.
You don't even add, that's my name. You just, is this your name? Yes, Your Honor. Is your date of birth correct on this document? Yes, Your Honor. Have you been, do you know your rights? Are you aware of what you're charged with? If you have a private attorney in advance, we've already covered all of that. We would have discussed the complaint and sent it to you in advance. We would have said, here's what they're charging you with. It doesn't mean you agree with it. It doesn't mean you think it's right, accurate, fair, any of that. It's just, do you understand what they are alleging against you? And once you see the document, yes, I understand. You are alleging I drove impaired, or I assaulted someone, or something. It will be very specific. So again, you're not getting into anything about the truth of the matter. So that you need to understand. You don't need witnesses. You're not bringing in character evidence. You're not talking about I'm an Eagle Scout. Nothing. It's just, do you know your rights? Do you know what's you are being accused of? Do you know, is this your name, your date of birth? And then how do you plead? And your attorney will assist in this with you, but you will say not guilty, or your attorney will say, my client pleads not guilty to these charges, and then you will get a date set for a pretrial. And I'll get to that because the word pretrial panics a lot of people. So that is it at the arraignment. And I mean, I think you can probably tell you may say a total of 20 words. No one will be asking you anything about your case. And in fact, if you try to speak about your case, the judge will silence you. And that's because anything you say is on the record and can be used against you later, and the judge is not entertaining that. If you don't have counsel present, they don't want a dog and pony show going on during the arraignment. It's not good. If you don't have someone, a public defender may step in and help you enter that plea of not guilty. Some people are like, oh my gosh, I can't, obviously you were drunk, or obviously this, and it's so annoying because if you don't understand this, 99.9% of the time, unless very rare circumstances, can you actually even plead guilty at arraignment. So when you watch the news and they're like, everyone's outraged, and these legal analysts are like, oh my goodness, he pled not guilty to these charges. And it's absurd because they know as well as every other attorney out there, you would never plead guilty at an arraignment. There's a very rare circumstance that would happen. You would have had to have been counseled long before the arraignment. Sometimes strategically, a certain type of crime may happen where you want to plead to the lower level crime before the state has facts that they could file more significant charges. But 99% of the time, a judge would never accept a guilty plea because guilty pleas have to meet certain conditions before they can be accepted by the court. And if you just now learned of your allegations, you don't meet that. And I'm not going to get into all the details of that, but you don't meet the legal standard to plead guilty. So for all of you folks who just are interested in, court protocol, that's why. A judge can't accept a guilty plea, but within these certain set of facts that make it, constitutional. So you're always going to plead not guilty. And going on to the pretrial does not mean you're going to trial. You could go to trial, but a pretrial, or you hear omnibus, sometimes a couple other phrases, but generally you'll hear a pretrial. We're going to set your pretrial for 6 weeks out. Think of it as a status. A pretrial hearing is a status hearing. The judge wants everyone to come back, and we want to know, what's the status? Do we need to put you on motions calendar? Are you going to argue some motions and you're going to go to trial? Do you need a little bit more time to get a resolution with the prosecutor? And some courts will accept a change of plea during that next pretrial, and some courts say, no, we now have to set you on a different calendar, the change of plea calendar, resolution calendar. So it's just kind of a bunch of scheduling is what it is. So the arraignment is significant because you find out what you're charged with, you enter your plea. Everything after that, up until either your change of plea or going to trial, is just a status. It's just kind of getting updated. and making sure everyone's moving towards a resolution. So that's why you will, as I said, maybe speak 20 words at your arraignment, and at a pretrial, you'll, for those who don't like speaking, you speak even less. You're going to speak nothing, or maybe 5 words. So just know that very little speaking, not a lot of it is expected. Don't bring in 20 people and fill the galley with chairs, and that will not be good. So nobody needs to be there. Sometimes your attorney will want someone there, and they'll let you know in advance. That's, again, kind of a rare circumstance, depending on your conditions of release, or if we're arguing bail. So that's a separate issue. Let's see. Also, when you should expect, where do I stand? How do I act? So let's cover that. If you are in person and your attorney is in person, very few courts are doing in person, but let's just say you're in one. So, or they'll say the defendant has to be in person for arraignment, but the attorney can be on Zoom. But let's say, for example, you're both in person. They call your case after they've called roll, and you've said you're present. They finally get to your case, and the judge calls you up. Okay, Mr. Smith, please come forward. And your attorney would join you, and you will go up either to like a desk, or you may go all the way up to the bench. The bench is where the judge is sitting. So you may go, like Superior Court, very often you go right up to the bench. Many district courts will have, a table. On one side will be the prosecutor, the other side will be a public defender sitting there. Sometimes a private counsel might sit there in preparation for their client getting called. So it'll be one of those two, either at the desk or the bench. But you will stand, and you will stay standing until the judge says, Mr. Smith, you may have a seat. If you're at the bench, you're just standing because there isn't a seat. You're just going to stand in front of the judge. In the rare circumstance you have something to hand up, you would hand that to the clerk, who will be seated to one side of the judge. But again, that's not even 1% of the time that you would have something that would be handled by your attorney in advance. But just so you know, if you did have something you had to turn in. Otherwise, it's just the judge will address you either at the bench or the table. If you are in person, which is often required for an arraignment, and the attorney is on Zoom, the judge will address the attorney on Zoom, but you will still just sit at the table or be standing at the bench. And again, same protocol. Yes, Your Honor. No, Your Honor. Only when it's directed to you. So again, 99% of the speaking will be your attorney, and your attorney will likely say, my client enters a plea of not guilty to the charges. So you may not even speak on that. So and the third option is where you're both on Zoom, which is quite common. At least where we're practicing is about 90% of the time. Occasionally you'll do in person just for arraignment, and then the rest of it will be on Zoom. So if you're on Zoom, you will unmute yourself when it is time. Make sure you're muted before, all along while you're waiting to be called. And just because you're on Zoom, do not show up in your pajamas, do not be smoking, do not, just because you're at home, or hopefully you're still taking it quite seriously. Don't show any sign of disrespect, no gum, no eating, no yelling behind you. You're in court. So think of it as the same. Just because you get to be at home or at work, you still need to show respect to the judge. So make sure I can't believe I'm saying this, but you're wearing a shirt. That's happened. So make sure you're clothed in appropriate clothing. And again, the thing that gets kind of the judges triggered is the mute and unmute. So if you don't know how to do that, practice that once with your attorney or a friend. Sometimes for people who aren't tech savvy, that could be an issue. It shouldn't be. It's really, really straightforward, but just, test that out. So you're going to unmute when it's your turn to speak, and then mute yourself as soon as you're done saying yes, Your Honor, or no, Your Honor. Don't risk being unmuted and having, your kids screaming in the background or the cat meowing or whatever. So mute and unmute, get really comfortable with that.
But again, your attorney's going to do 99% of the speaking, so hopefully you're not too anxious and you're comfortable with that. And if you hired an attorney in advance, they should be able to kind of give you the basics of what to expect, what they're going to say on your behalf for your specific case. And I think that pretty much covers it, just it isn't complicated. I will try to get a video done on how to prep for trial, because that's a whole different issue, and a lot goes into that, and it's a lot of prep. But be aware, the one thing that kind of really causes anxiety for people is hearing that word pre-trial. And just so you realize, it does not mean you're going to trial on that next court date. So hopefully this is helpful. I'd appreciate it if you hit like and subscribe, and if you have an idea for another video, put it in the comments below. Thank you.